All right, we will check back in with Charlie Wojciechowski and Phil Rogers. We'll keep an eye on everything happening there in Kenosha, Wisconsin after the verdict in Kyle Rittenhouse's trial. Not guilty on all charges. And joining us right now is legal expert, attorney and professor of law at Concordia University, Thomas Glasgow. And Thomas, tell us your reaction to hearing the verdict just minutes ago.
You know, I'm not really surprised from a legal basis. When you take all the politics out of this, this was an extremely difficult case for the prosecution. When you ended up having a person who was out into a crowd and you end up hearing what Charlie was mentioning, where you end up with gunshots. You mentioned, the person who was pushing flaming dumpsters into the gas station and into other places. Was he reacting to what occurred? And when you watch the videos from, again, a legal standpoint, did he have the right to end up utilizing deadly force? So in other words, was he in imminent fear of death or great bodily harm? And if the answer was yes, which the jury concluded that he was, then he did have the right to use deadly force. And now you had three separate victims here. And when you had three separate victims, you had to determine if he had the right to do that with each one of them. And with the first gentleman who approached him, that was right after the gunshots. The second one, he was being hit with a skateboard. The third one actually admitted on the stand that he pointed a weapon at him. So the questions then become for the jury is, did he use the appropriate amount of force? So from a legal perspective and in the legal community, most all of us believe that this was going to be a not guilty as to the intentional acts of homicide. The question really became, was he going to end up with a lesser included? And if he ended up with a lesser included, what would that be? When the state ended up asking for the lesser included, it ended up signaling to everyone involved that they really didn't have the faith that they thought they had in the case, and that the evidence didn't come in the way that they thought they could end up getting the intentional homicide. As a result, the time that we ended up looking at the jury being out deliberating, most of the time they end up coming back with the lesser included, the compromise verdict, because clearly they were talking about something. And they were talking about whether or not he actually pulled the trigger and killed the people. And again, murders are not whodunit when you indicate self-defense. And when you indicate self-defense, you have to admit the crime in order to assert the affirmative defense. It then became incumbent upon the jury to determine whether or not he used the appropriate amount of force. So all in all, based on the evidence which was adduced and how the case was argued and how it was put forth, it's not surprising that it was a not guilty. It is surprising that they didn't come back with some lesser included, which I thought most everyone thought there would be at least one lesser included involved.
Which of the lesser included do you think it would have been? The recklessly endangering public safety?
Well, the different charges were one thing. When you end up with, there's a differentiation under the law between a perfect defense of self-defense and an imperfect defense of subjective self-defense. So if I objectively believe that I am in imminent fear of death or great bodily harm, and someone is swinging a chainsaw, say, 5 feet from me, am I in imminent fear of losing a limb or being killed? The answer is yes. Objectively, anyone would agree with that. But subjectively, if you believe that, say, a person is much stronger than they actually are, or if they have the ability to do something, you believe the person is, say, a karate expert or something of that nature, and they're going to end up killing you or causing great bodily harm, and they actually aren't, or you don't have that subjective, or excuse me, you have that subjective view where it's not objective. Another person wouldn't rationally believe it. It's an imperfect defense, which comes back with a second degree, which would be something along the lines in Illinois of a manslaughter, or where you've got a second degree homicide, which is commonly referred to.
So, Thomas, why do you think you and other legal experts have said the same thing, thought it would be not guilty, at least on the most serious charges? Why do you think the jury took 4 days to deliberate then?
Because I think that the jury, number one, really went over the evidence. As I have indicated in the past, when we've done juries before and when we do juries, talking to the jurors afterwards, they really take the case seriously. They look at the case and they consider themselves experts on this case, not you, not anyone else. They believe they are the experts because they've seen all the evidence, they've been paying attention. So they go over, number one, the jury instructions, because that's their Bible, and they look at it. Here's the rules of how we're going to play the game. And then they end up taking each piece of the evidence and they try and fit it in to determine whether or not the prosecution has proved their case. What was really astounding to me during the course of this case and watching this case was why this wasn't passed off to the attorney general, why this wasn't given to someone in the state of Wisconsin that had a much deeper field of attorneys to prosecute, that had the depth and breadth of going forward, trying homicide cases and knowing what and how this should have been presented on a larger scale. Kenosha County is something where, although you have homicides in Kenosha County, the Attorney General's office, just like the Attorney General's office in the state of Illinois, has units that go statewide and end up helping and assisting in prosecutions in smaller counties. So this is something that I questioned from the onset of why it wasn't given to another agency for them to prosecute. But this is what Kenosha County chose to do, and their district attorney's office went forward on their own. Now, it resulted in what appeared to be several mistakes by the prosecution, up to and including not giving an appropriate copy of the video to the defense during the course of this, commentary on people's right to remain silent during the course of the case and during the course of closing argument. Those were all issues which, if he was found guilty, would have been grounds for appeal and would have been addressed by the appellate court as to whether or not he would have had to be tried a second time.
So, Thomas, what did you think about the prosecution calling Rittenhouse an active shooter and saying he cannot claim self-defense because he put himself in that dangerous situation and caused the situation he found himself in? What did you think about the prosecution's argument to that?
That's an excellent question, because in the law and under the law, if you are the aggressor, you cannot avail yourself of self-defense. So you cannot start a fight and then claim self-defense and be absolved from the crime. So in this situation, that was the tactic of the prosecution in going after him, to say, hey, you were the one who came here. You didn't have any right to be here. This wasn't your property. This wasn't your fight, so to speak. You came from Illinois, out of state, even though it's about, a 20-minute drive over the state line. It's still, hey, it gives the perception of, this is another state that you're coming to in order to inject yourself into politics and inject yourself into a situation which you really had no right or interest in being in. You didn't know the owner. You didn't know the owner of the car dealership. There were no cars on the site. He had removed the tools. All the things that the prosecution said, which is a good tactic to use. Calling him an active shooter, I think, was kind of a red herring, because he wasn't really an active shooter. He wasn't going around indiscriminately shooting people. He shot 3 people that he ended up in an altercation with. Now, the question the prosecution really should have painted, and why, is, did you begin this fight? And if you did, how so? And they didn't do a really effective job of showing that he was the provocateur in this, that he was the one who instigated the incident. So because of that, I think they had some real problems in negating his self-defense claim, giving the defense the opportunity to end up claiming that there was a legitimate self-defense claim. And then going to the second stage of, is it a perfect self-defense claim, or is it an imperfect self-defense claim where it's subjective versus objective?
All right, Thomas Glasgow. Also, the judge faced some criticism for the way he was making decisions and possibly ruling on things, including saying he might declare a mistrial even after the verdict came out. Were you surprised that he made that statement? Is that something that judges can declare a mistrial after the trial's over?
They absolutely could have. The judge in this matter said that he did not believe that the prosecutor was acting in good faith. That statement of him not acting in good faith is something that is the cornerstone of why there would be double jeopardy that would attach. You can have 2 types of mistrials. You can end up having a mistrial where the person just is retried. Hey, we all made mistakes during this, but there wasn't any due process that attached. So therefore, we're going to just get a do-over. The second one is where the prosecution willfully does something to impede due process, and they do it out of bad faith. And in this situation, he violated one of the pretrial rulings where the judge said, you can't go into this area, yet he did go into that area. And because he went into that area, violating the judge's order and making commentary on things that are sacrosanct under our Constitution, he injected into the trial reversible error as a possibility because the judge said, I don't believe you were acting in good faith. Now, could the judge have declared a mistrial after the fact? He absolutely could, and he reserved his ruling. And I think it was wise for the court to reserve their ruling in this matter. And the reason being is because we place a great deal of weight on the jury system, and we place a great deal of weight on the jury being the one to decide the evidence and not the court when you end up having the jury trial. Because we would put a lot of faith in the jury system. We built it into our system as a safety valve against the government, and having laymen decide the guilt or not guilty of whether or not a person has committed a crime is something that is unique to this system, and it must be protected by the courts. So his reservation of that ruling was appropriate, and if he had to deal with it, he could have dealt with it after the fact. Now, could he have ruled that there was a mistrial? Yes, he could have. Could he have given the prosecution another chance to try him? Absolutely, they could have. The court also, based upon his statements, could have ended up ruling that there was a mistrial and that due process had been violated since the prosecution went into areas which they shouldn't have gone into. And as a result, he could have barred that retrial, and Mr. Rittenhouse could have walked away. But that's a moot point because it didn't happen. The jury came back not guilty. You don't appeal a not guilty.
Also, the judge decided to allow a juror's request to take the jury instructions home, even though the defense and the prosecution did not seem to want to allow that to happen. What did you think of that judge's ruling last night?
You know, I found it to be very odd. I've practiced in criminal law for almost 30 years, and I can't tell you how many juries I've done. I've never, ever, ever seen a judge allow someone to take jury instructions home. Part of it is there's an initial instruction that's given that they are not to allow outside influences to affect them. And the jury is the pool, that one unit of 12 people is supposed to, as the collective consciousness, make the decision without any interference from the outside, no matter who that person may be. Allowing someone to take the jury instructions home allowed that person to either check the internet, read online, or to have a significant other or a cousin or a friend inject in to what was being told to them in the jury instructions, which is solely the province of the jury. And the jury were the only people who were supposed to decide on what those instructions were to end up being defined by the evidence. And it's unfortunate because I don't think it was something that would have benefited the prosecution had he been found guilty. I think that they would have ended up having grounds for appeal based on that as well.
Thomas Glasgow, attorney, legal expert, thank you so much for your time. As we are keeping an eye on Kenosha right now after the jury has decided the verdict in the Kyle Rittenhouse case, not guilty on all charges. We have another reporter there. Regina Waldrop is on the ground. Let's check in with her. What have you been seeing and hearing since the verdict, Regina?